The Renters' Rights Bill cleared the House of Lords on the 21st of July when it had its third reading after 6 long months in the House of Lords. This means that the bill is now in its final stages and is likely to receive royal assent in September in good time for the Labour Party conference. No doubt Angela Rayner is going to be very happy about that. So what does this mean? And more importantly, what happens now? What about the amendments that the House of Lords voted onto the bill against the government's wishes? And what's the latest on pets? Well, in this video, I explain all of this and what we can expect in the coming months, as I'm recording this on the 22nd of July, 2025. And stick around till the end, as I also share my estimates on when I think the main bits of the Renters' Rights Act will come into effect. In other words, the abolition of Section 21, no-fault evictions, the abolition of fixed terms, everything becoming periodic, the new rights for tenants to have pets, and a whole host of other rules. And who am I? I'm Suzanne Smith. I'm a solicitor, and I worked for 25 years as a corporate lawyer before becoming a landlord in 2019. And I set up the Independent Landlord website and this YouTube channel to share the benefit of my experience as a corporate lawyer, my way of looking at the world, and also to provide reliable information for landlords and everyone in the PRS. You can keep up to date for free by signing up for my weekly newsletter at theindependentlandlord.com/subscribe. Right. Let's see what happened at the end of the third reading.
The question is that this bill do now pass. As many as of that opinion will say content, contrary not content, the contents have it.
The contents have it. And that means that the amendments voted on by the House of Lords are now on the face of the bill, for now at any rate. So what does it mean when I say it's now in the final stages? It does sound a bit dramatic. Well, it means that the bill now goes back to the House of Commons on the 8th of September, after the summer, and the House of Commons with its large Labour majority.
As many as our opinions say aye. Aye. The contrary, no.
And they'll consider the amendments that the House of Lords has made. And then they send it back to the House of Lords, and it can go backwards and forwards a few times, which is why it's called ping pong. And well, what will they be arguing about in ping pong? Well, the government lost a number of votes at the report stage of the House of Lords, and there are now new amendments on the bill that the government opposed. But don't get your hopes up. None of them changed the fundamentals of the bill, despite all the commotion of the 300 or so amendments that were tabled at the committee stage. Only a few managed to be voted onto the bill. And let me go through them quickly now so you have realistic expectations and you know what the House of Commons is going to be looking at. Everything else is now settled, unless the government decides to change its mind, which is unlikely, although I'm hoping they'll do that on pets, but I'll come to that in a minute. There are only 4 non-government amendments that made it onto the bill that are of any consequence to the average landlord. And I'll go through these now. Well, let's start with pets. Rather surprisingly, and rather foolishly, in my view, the government changed its mind about pet insurance. They said that there aren't any products available, which incidentally isn't true. A number of companies are in the process of launching them. But the government has removed the ability of landlords who ask tenants to take out insurance for pet damage or to get them to pay for it. Now, that doesn't make sense. Anyway, a crossbencher called the 28th Baron de Clifford, which incidentally is one of the oldest feudal titles, which, if not the oldest, which goes back to 1299. Anyway, the Baron de Clifford proposed an amendment to allow a landlord to ask for a pet deposit of up to 3 weeks' rent, which passed narrowly by 206 votes to 198. I can't understand why the government is asking landlords to take on more risk by making them accept pets without giving them a bone in return. Unless there's a good reason to refuse, like a lease forbidding it, landlords are going to have to accept pet requests. I hope that this amendment about pet deposits gets onto the bill, or that the government does another U-turn on pet insurance, as it really doesn't make sense for them to scrap it. I guess that instead, if neither of these get onto the bill, landlords will end up charging a pet rent for everyone to take account of the increased risk, which will push up rents further for everyone. And I support pet insurance and think it's frankly daft for the government to remove it. Right, moving on. I don't often get into the politics, but that's not really politics, it's just practicalities. The next one is an amendment to Ground 1A under Section 8. And this is the new Section 8 ground that enables landlords to get an order for possession if they intend to sell. This is another amendment by a crossbencher, the 7th Baron Cromwell, another hereditary peer. So the previous version of the bill had a provision in it that if you use Ground 1A and a tenant moves out, you can't relet your property for at least 12 months, even longer sometimes. And this holds true even if you can't sell the property or if your sale falls through. The government introduced this to try and stop landlords gaming the system, but it is a really tough rule. And the amendment reduces that restricted period during which landlords can't relet the property or put it on Airbnb from 12 months to 6 months after the tenants move out, with some protections to stop landlords gaming this ground and ensure that the sale attempts are genuine. And this passed by a narrow margin of 213 votes to 209. The government opposed this, and I predict that they'll dig their heels in on this and use their majority in the House of Commons to keep it at 12 months. But let's see. Let's move on to student lets. The previous version of the bill included a new ground 4A, which would allow landlords of student HMOs to serve a Section 8 notice to recover possession between the 1st of June and the 30th of September if they fulfill certain conditions. A Conservative amendment made it onto the bill by 221 votes to 196, so a bit more of a margin, and that extends this to all landlords of all student properties, regardless if they're HMOs. For instance, it would include one person in a flat or two sharers in a flat. And so all student landlords would be able to use Ground 4A to bring the tenancy to an end between June and September, and that way making sure that when they want to relet it for another lot of students, that they'll be able to recover possession, or at least have the ground for possession, and they might have to go to the courts, but at least they've got something to send the tenants. I suspect that the government won't back down on this one either, because it's something that they've really pushed back on a lot during its passage through the House of Lords. So the final one is a little bit techie, but it's important. It concerns what's called the burden of proof for local authorities if they want to issue a civil penalty to landlords for rental discrimination. So that's no kids, no pets, and rental bidding. And so that is if landlords accept a higher rent than the rent that they have in the advert when they list the property. The government's version of the bill had a civil burden of proof, a balance of probabilities. And so that means more likely than not. It's actually relatively easy to prove. But the Conservatives managed to get their amendment through the vote to change it to the criminal standard, which is beyond reasonable doubt, which is not only a lot harder to prove, but it makes it consistent with the myriad of other instances in the bill where local authorities can impose civil penalties. The government lost the vote by 14 votes, and I suspect the government will try and reverse this during ping pong. The other amendments are pretty specific. For instance, having a moving in ground for carers and expanding the agricultural workers ground. But that's it. It's not the big deal that many people were hoping for. And so all the fundamental parts of the bill will remain on the bill. So what happens next? On the 8th of September, the ping pong stage starts, as I mentioned before. And then we'll get royal assent. Nothing much will happen then, other than the name will change to the Renters' Rights Act. And the government will then start publishing regulations with some of the detail. And they'll also be running a media campaign to inform landlords that the law is changing. But you already know that if you've been watching my videos, and you've already had my take on it all, not the government's. Then the government will announce when it's going to come into effect. And my current guesstimate is Q2. And you can keep up to date by subscribing to this channel if you haven't already, as I plan to put out a lot more content, including a training video of the final version. Also, you can sign up for my free weekly newsletter at theindependentlandlord.com/subscribe. A lot's going to be happening in the coming months, and you can rely on me to keep you up to date, telling you as it is without all the drama and the politics. And if you've got this far, please give the video a like. It really helps. See you soon.